I want to cross over to the Supreme Court live and listen in to Isaac Lenaola's interview that has just begun right now.
Two things that make me qualified. One, my role in making this constitution. My fingerprints are around here. And number two, my service as a judge, both here and in the East African Court. My jurisprudence is well known, and I think that is a plus for me in this journey.
Thank you, Judge. We are going to proceed with the questions. Also, feel free, in case you need any clarification, stop us at any time, and we'll do just that. Let me invite Commissioner Attorney General to start first.
Judge, I am one of those who would start by admitting our past association in writing the Constitution together and litigating cases before your court. Having said that, I have two questions. Question number one relates to your own judicial philosophy. I would like you to share with the Commission your philosophical inclination in terms of how a judicial officer in the highest court of the land should handle constitutional controversies. That's my first question.
Well, thank you very much, Honorable Attorney General. I consider myself to be a liberal, pragmatic judge. If you look at our Constitution, you'll find that Article 259 enjoins us in a particular way in dealing with constitutional questions. I call myself a liberal because I'm not certainly a conservative. I'm a liberal because my thinking is towards doing justice to every case, depending on the circumstances. I'm also pragmatic because in my judgments over the last 13 years, I've made judgments that are realistic and pragmatic and able to have a person walk out of my court feeling justice has been done to them. And so I consider myself such a judge. If I may give an example, over the last 5 years, in the division that I head now, I've given decisions like the CDF decision, which I sent to you, where it would have been very easy for us and myself as presiding judge to say, CDF is dead, it's unconstitutional, and that's the end of it. But we said that because there are certain consequences upon such a decision, we said let the decision take effect after a year so that the programs and projects under the CDF Act can continue and be finalized within the financial year. That is sort of philosophy that I espouse now and in the future.
Let's dig a little bit deeper with reference to what I call the penumbra claims on the Constitution, the claims that are not quite clear in the Constitution. And I want to start with LGBTI. You made a decision that this body espousing the rights of persons describing themselves as such should be registered by the government of the Republic of Kenya. A pending claim, I believe, in your court, and I don't want to discuss the specific, is the claim by the atheists of the Republic of Kenya. Without the specifics of these cases, I'd like to understand your own philosophy as to how ought the judiciary address this sort of claims. Is it slowly, progressively, incrementally, or otherwise?
Thank you very much. On the LGBTI question, let me make it clear that in the Eric Gitari versus Attorney General case, the issue really was about Article 36 of the Constitution and whether Eric Gitari, as an acclaimed open homosexual in Kenya, was entitled to associate with others of his kind under Article 36 of the Constitution. So that the question in that case was not per se LGBTI rights. It was the question of association. And Article 36...
A view to campaigning for.
Yes, for those rights. And so Article 36, if you look at the language of it, is that any person can form, participate in, and associate with others in an association of any kind. And number two, the limitation under Article 34, therefore, in the response that came from the NGO Registration Board, was that we have no problem with your name, well, with your purport. We have a problem with the name of your association. And we said, if you look at Article 36 again, the limitations are that it cannot be given unreasonably. And we thought, as a bench, that the refusal to register an association merely because of the name LGBTI was unreasonable. And the defense given under Article 24 could not be sustained. However, in the cases that are coming, and I mentioned them on Friday this week, there is a specific attack on Section 162 and 165 on sodomy and the question of order against nature offenses. Now, what is the penumbrum of my thinking as a judge around these questions? Society is a society that must appreciate the laws that are made for it, because law is not made for man. Law is not made for man. Man is made for man is made for law, not the other way around. Law must appreciate the context of the society that we live in, so that if you recall, Honorable Attorney General, Article 27(4) caused a serious crisis in the making of the Constitution because of the additions of the words sexual orientation in the first draft of the Constitution in 2002.
In fact, Judge, you have brought me squarely to my last question.
Yes.
We know that when this Constitution was drafted, certain issues were put on the table and were rejected by the public.
True.
One of them is same-sex marriage.
True.
And that's why we wrote a phrase there, you will recall, that you probably will not find in any constitution in the world. I think a stranger reading the Constitution must find it very strange. Marriage is between a man and a woman.
Yes.
So that issue was on the table. Death penalty.
Yes.
The issue was on the table.
True.
The public refused it. And we could go on and on. Abortion.
True.
The issue was on the table in an open-ended way, and the public refused it in that way. Would you be worried if the judiciary were to, in a progressive manner, purport to reopen those issues and not settle them politically now, but settle them judicially?
Yes, I would, without going into the cases that are before me already. And I think there's a particular case that I'd use as an example. If you look at my judgment in Baby A, the intersexual judgment, I deliberately refused to declare intersexuals a third sex because I said that's not a matter for the courts. That's a matter for elsewhere. I could have become progressive in that sense to say intersexuals have both sexual organs and therefore they're the third sex. I didn't say that. I only said to the extent that this is a child, the child shall have rights. But the court cannot be the one to say, a single judge like myself, let us now create a third sex for Kenya and the rest of Kenyans must follow my thinking. So I think judges must be differential to the purpose for which a constitution is set, but judges at some point can give guidance to society without particularly taking the place of society in making their decisions. And that is my view.
I thank you, and I wish you well.
Thank you.
Thank you. Commissioner Agenda.
Judge, I will ask you a few questions. I have agonized over some of the decisions that you have made as a judge of the East African Court of Justice, where you have served, as you said, with dignity. And you are a deputy
Principal
judge. I just want to ask you small questions. How long do you have to serve in the East African Court of Justice?
I am the longest serving judge in that court.
Yes.
I have got 6 more sessions to go and I'm retiring.
When are you retiring?
Early 2018.
Early 2018.
Because we only have 4 sessions a year. I've got 6 to go.
So would the work in that court for the remaining short term be an impediment to your work if you are given a chance to serve in the Supreme Court?
No, not at all. When I went to that court, I brought the proposal to appoint me to this commission, and the commission allowed me to go. If the commission were to recall me and say that you're needed more here than elsewhere, I'm quite willing to.
So you'd be willing
come back.
to basically.
Absolutely.
Okay, thank you. Now, second question, on the application of the principles, specifically I want to go back to 2005, the protocol of the Customs Union that was, of course, promulgated pursuant to the Treaty for the East African Community in 1999. There are two principles that stand out, and maybe you want to guide me on, just tell the Commission how you've applied the two principles in that treaty. The principles of asymmetry and variable geometry, and whether you've applied them to your decisions.
The East African Community Treaty has Article 6, Article 7, Article 8. These are the principles by which the community must operate. And they are divided into operational principles and principles that are around the question of rule of law and good governance, 6D and 7.2. Variable geometry is an interesting principle which is in the treaty. And it's about the question of unanimity, consensus building by the organs of the community. The variable geometry principle is to the extent that there cannot always be unanimity even in consensus. And therefore, for example, if we were to build a highway between Mombasa and Kigali, you can agree that yes, we're going to build the highway. But only Kenya and Rwanda can begin doing their bit, and Uganda can remain behind because of its own difficulties.
So the coalition of willing is essentially, is that part of that?
We wrote a judgment around that question, and we were a bit uncomfortable with the question of coalition of the willing. But the geometry question was addressed in application number 1 of 2008, and the court was clear that unanimity and consensus can be built around that particular principle.
On evictions, I think you wrote a very interesting judgment in Satros, Ayuma, and Eji on evictions. What informed your decision on evictions? Because you departed from the norm, from the general norm. Just give us the basis and the philosophical foundations of that decision.
Thank you. Satros Ayuma is a judgment around the Mudhurwa flats, which we all know because I'm sure most of us have used Jogora in our lives. And there was a problem about the eviction of the tenants in that apartment block. Some were pensioners for the railways, some were their children, grandchildren. And the question is, when I realized that I had the opportunity as a judge to address the very thorny question of evictions, I thought I should use that judgment to lay down the law, in my view, regarding evictions. And so I said, although these people will have to leave the apartment block at some point, they must leave with dignity. Some of them were old, some had children, some were sickly, some were in school, some were old. And I said, we must have in this country certain conditions, preconditions to be met before anyone can be evicted, even if you are living on some land unlawfully. So I said, you can't evict people at night, you can't evict them during school holidays, you can't evict them on a Sunday, you can't evict them without security, you can't destroy their properties. And I'm happy to say that when I read the Land Act amendment that just came in the other day, Section 152G of the Land Act took all the principles that I had borrowed from the UN and from other places and codified them into law, so that the issue of evictions in this country is no longer a question of my judgment in Satros, nor a question for the police and the AP and the provincial administration to just do willy-nilly. It is now in the law, thanks to that judgment in Satros Ayuma.
Now it's in the